Hello aspirants, and welcome to another high-yield explainer right here at Rungta IAS Academy. Today, we're unpacking a very crucial update for your General Studies Paper 1 Geography syllabus.
Absolutely, ma'am. It's great to be here. We'll be looking at the absolute latest developments in the Mekedatu water dispute. Let's dive right into this because, frankly, it has direct, immediate implications for both your mains examination and your upcoming personality test.
Right, so to really understand this dispute, we must first picture the terrain. What you're looking at is the rocky basin of the river at Mekedatu, down in Karnataka. This is the exact proposed site for the Mekedatu Balancing Reservoir cum Drinking Water Project.
Exactly, and understanding the topography here is step one for any serious geography aspirant trying to map out interstate water infrastructure, and of course, the inherent challenges that come with it.
Now moving to the core legal update. The Supreme Court of India has just officially dismissed a review petition filed by Tamil Nadu regarding this very project. Yes, ma'am, and the critical legal terminology the Supreme Court used here is premature. The court essentially reaffirmed its earlier stance. They're saying that Tamil Nadu's challenge to Karnataka's proposed project is simply too early at this current stage of development.
Let's trace this chronologically, which is absolutely vital for structuring your mains answers. Following the initial decision back on November 13, 2025, the review petition was then formally dismissed on April 15, 2026.
And aspirants, please note a specific procedural detail right here. This review petition was dismissed via circulation in the judges' chambers. This was by a bench comprising Chief Justice of India, Surya Kant, along with Justices Vinod K. Chandran and Vipul M. Pancholi.
So you might be wondering, what exactly is the Supreme Court's reasoning? Why call it premature? Well, it all comes down to the role of expert bodies. You see, Karnataka has submitted a detailed project report, or DPR.
Precisely, ma'am. The court noted that this specific DPR is currently under active consideration by highly specialized bodies, namely the Cauvery Water Management Authority, or CWMA, and the Cauvery Water Regulation Committee, the CWRC. The judiciary is essentially taking a step back and saying, let the technical experts do their job first before the courts intervene.
But it's very important to note, the court didn't just side with Karnataka. They carefully balanced the equities by strictly protecting lower riparian rights. Absolutely. And that is a crucial geographical and legal concept for you to grasp. Lower riparian states, like Tamil Nadu and Puducherry, are situated downstream. The Supreme Court made it explicitly clear that if the DPR is eventually approved by those expert committees, these affected downstream parties are legally free to take necessary measures in accordance with the law at that time.
And this brings us to one completely non-negotiable figure, 177.
Yes, 177 TMCFT. The Apex Court heavily emphasized that regardless of the Mekedatu project's outcome, Karnataka is absolutely bound to release this specific quantum, 177 TMCFT of Cauvery water, to lower riparian Tamil Nadu and Puducherry. The water share mandated for the downstream states remains completely, unequivocally protected.
Let's analytically look at the interstate dynamics now, which gives you excellent context for GS Paper 2 as well. We see a very clear contrast in how both states have reacted to this. Tamil Nadu's position has consistently been to object and file review petitions against the reservoir.
Right, and on the other side, Karnataka has welcomed the decision. Karnataka's Deputy Chief Minister D.K. Shivakumar, who also holds the water resources portfolio, called the Supreme Court stance good news. He also confirmed that Karnataka is currently in the active process of submitting the revised, detailed project report.
Yes, and Mr. Shivakumar publicly acknowledged the Supreme Court's clear instructions, noting the strict condition that Tamil Nadu's mandated share of water must be released in a year. This is a perfect illustration of how the Supreme Court is maintaining a very delicate balance here. It allows Karnataka to proceed with expert technical reviews of its proposed infrastructure, while concurrently strictly safeguarding the downstream water security of Tamil Nadu.
So the crucial takeaway from today's explainer is really how geography, law, and administration seamlessly intersect in these water disputes, which leads us directly to a potential personality test question for you all to practice. Consider this for your upcoming mock interviews. How does the Supreme Court's reliance on the CWMA reflect the role of expert bodies in resolving lower riparian disputes? We strongly encourage you aspirants to utilize the structured points we've covered today, the timeline, the DPR process, and the protection of downstream rights, to frame a well-balanced, highly analytical answer. Keep studying hard, stay objective in your answer writing, and we'll see you in our next explainer. Thank you for joining us.